So the question is, who has the power? And right now the courts are saying, well, that's in the hands of the General Assembly. Tony Katz, 93 WIBC, good morning. It's good to be with you. This was the conversation of whether or not the General Assembly is allowed to call itself into session, a special session, to, example, look at emergency orders from the governor. What Governor Holcomb said is, you don't have the power to call yourself into special session. The Constitution of the state is clear. Only the governor can do such a thing. Veto. The General Assembly said, vetoes, we don't need no stinking vetoes. And boom, an override. Governor Holcomb sues. It goes to the courts. And a Marion County judge ruling that the state constitution gave the General Assembly the authority to determine when and for how long it will meet. Todd Rokita joins us right now, the Attorney General of Indiana, on the drivehubler.com hotline. And, sir, this seems like the result that you were looking for. You referred to it as a huge win for the people of Indiana. What is it you mean by that?
Well, hey, Tony. Well, it's quite clear. I mean, separation of powers is there for a reason. In order to preserve individual liberty as best you can, you want to decentralize and separate as much power as you can. That's what our founders knew from their experience with England when they wrote the federal constitution, and Indiana's framers did the same thing. So far, so good. Who knows if it's over yet? The governor may try to appeal this, and so it could be the sixth inning of a baseball game, or it could be the ninth inning. So we'll see.
But the governor's point of view is that the Constitution does not allow for them to call themselves into special session. So how can they decide to call themselves into special session? This Marion County judge says, well, it's the General Assembly. They can call themselves in whenever they want. Was it your advice to the governor's office that, of course, the General Assembly can make this call on their own?
You know, it was. We've been saying it's constitutional all along, but even beside the point, the governor might have an opinion about what's constitutional, not just like you might have an opinion, or even me. But that doesn't mean the governor has a right to sue. Right? The people of Indiana have already paid for their attorney, and that's my office. And so there's still that lingering question. You know, I imagine the governor has run up probably $200,000 or so of legal fees, and the question still remains: why? And is that even authorized? And it's not. I mean, the statutes are clear that the Attorney General is the attorney for the state. And the analogy is this: GM. Think of the company GM. You never see Buick suing Chevy. Right? Just like you shouldn't see the General Assembly or the governor suing each other. It's Tony Katz, if it gets a bad car, may sue GM. And that's how this is supposed to be structured from the beginning. And for good reason, Tony. You don't want governors suing legislators and vice versa over policy disputes, which this is. The governor is not the final arbiter of the Constitution. We all swore an oath to defend the Constitution. So if this precedent is allowed to stand where governors can sue legislators and vice versa, costs are going to go through the roof, and you will overpower the judicial branch. You will make them super legislators, which even they would say, I'm sure, that they don't want to be.
Talking to the Attorney General of Indiana, Todd Rokita, on the drivehubler.com hotline. This was an argument that you were making, that you are the lawyer for the governor. The governor is still able to, as we saw in some rulings, make their own decisions, hire their own people. The question before us is whether or not this continues, whether or not this goes down the line, whether or not the governor decides to push back on this. If he does, this is going to the Indiana Supreme Court, or is this something that can go a little higher?
No, I mean, it would end at the Indiana Supreme Court. This is completely a state issue. There's no federal question here that would bump it into a federal district court or anything like that, or federal appellate court or anything like that. So, this is where it'll end if an appeal is requested, and we'll see. But really, I've been directly involved in this case from the very beginning. And in fact, going to the to the governor and saying, "Hey, please don't do this." And for all the reasons,
you did speak to him. You
stated.
spoke directly with Governor Holcomb and said, "You don't have it here. Don't go forward."
Oh, several times, and my staff even more. And then we wrote a 16-page, very nice letter saying, "Hey, here's all the reasons why." And he wrote me a one-pager back saying, "Well, Democratic retired Judge Frank Sullivan said it's okay, so we're going to do it."
When the governor, if he were to decide to fight this, will you be writing that letter again? Hey, don't do this, or will it be a little louder?
Well, no. I mean, it isn't personal or anything like that. It's something I would do for any client that we would do. But, by the way, my staff has done an excellent job. Speaking of staff, we had an excellent team on this case. They're the same kind of attorneys and same attorneys, in fact, that work on hundreds of cases for the people of the state of Indiana with just as much vigor and just as much concentration, saving taxpayers millions of dollars a year, not only in legal fees, but in judgments that we're able to get in favor of taxpayers. So it's the same crew. We did not hire outside counsel or anything like that for this. It's the same public servants that help in all our cases, and they really deserve. They argued it well and they briefed it well, and we'll see where it goes from here. Like I said, it may not be over, but that's the point I want to make. But the governor has decided what he wants to do, and it'll be all figured out, including whether or not he was authorized to spend that money.
Well, whether or not he's authorized to spend money in a lawsuit he felt fine in bringing, that's an interesting question. But before I let you go, Attorney General Todd Rokita, let's get now to the idea of what's causing this in 30 seconds or less, the executive orders that have been coming from Governor Holcomb. Is that allowed? Can he do month after month after month of executive order regarding health?
Well, under the current law, he can. But, now we have this law where the General Assembly can come in if they decide to and perhaps curtail those orders by passing another law. So, that was the check and balance, and that's what this lawsuit's all about. And, again, the people won last night when that opinion was issued because we have a separation of powers, and it keeps people more connected to their representatives, which allows them to come in and call themselves in, so that they can pass laws or prohibit things on behalf of the people.